very busy month. Of course, we have the Human Rights Council going ahead, but I know there are also many other streams of negotiations unfolding. So we really appreciate you taking the time to join us today in person. And also a very good afternoon to those of us following us online. It's my pleasure to welcome you to the Geneva Dialogues on Human Rights and Climate Change. This year's event title is The Role of Geneva in Building on the Historic Advisory Opinions on Climate Change. The event is organized by the Center for International Environmental Law, the Office of the High Commissioner for Human Rights, the Permanent Missions of Vanuatu and of the Republic of the Marshall Islands, the Geneva Environment Network, Earth Justice, and the Friedrich Ebert Stiftung Foundation, with the support of the government of the Grand Duchy of Luxembourg. My name is Francesca Mingrone, and with the Center for International Environmental Law, I will be moderating the first part of this event. Before I introduce you to our panel, a quick housekeeping rule. This event is set to last a couple of hours. As I was saying, it's live streamed. But at 5 p.m., once it's over, we'd really like you to stay a bit longer with us and join us for a small reception at the Serpentine to foster some further conversations. Let me introduce our panel. We're still waiting for one of the panelists for the first segment. Apologies for that. I have the pleasure of introducing you, Ms. Sandra Merens, Deputy Permanent Representative of Luxembourg to UNO. His Excellency Sambo Antas, Permanent Mission of Vanuatu to the United Nations Office of Geneva, of course. Her Excellency is Doreen de Broom, Permanent Representative of the Republic of the Marshall Islands. And we're waiting for Mr. Miguel Ruiz Botero, Secretary of the Permanent Mission of Colombia. Let me share a few words on why we are here today. The Geneva Dialogues have now become an annual moment of reflection on some discussions and specific themes with regard to the intersection between human rights and climate change. And for this year's edition, the choice was very clear. Between 2024 and 2025, the three international jurisdictional bodies have released landmark advisory opinions on states' obligations with regard to climate change. A bit more than a month ago, on the 23rd of July, 2025, the International Court of Justice delivered its advisory opinion on states' obligations in respect to climate change. This was mandated by a resolution of the General Assembly adopted by consensus back in March 2023. The International Court of Justice had, for the first time in its history, the mandate to address the obligations of states with regard to climate change across different bodies of law, whether it's treaty law or customary law. That, of course, includes international environmental law and human rights law. And the advisory opinion that is before us now does exactly that. It delves into relevant obligations of states across different bodies of law, including human rights, and provides guidance on a number of important aspects. We can mention here, for instance, the role of science, the standard of due diligence, what are the root causes of climate change, what are the obligations regarding remedy and redress, the issue of statehood, the right to healthy environment, and so on. The advisory opinion on the climate emergency by the Inter-American Court on Human Rights, which was requested in January 2023, was also delivered in July 2025. It's a very progressive ruling that clarifies states' human rights obligations with regard to climate change and also addresses, once again, important dimensions, including the question of the rights of future generations, defenders, corporate accountability, the right to a clean, healthy, and sustainable environment, the rights of nature, procedural rights, and so on. And in May 2024, the International Tribunal of the Law of the Sea delivered an advisory opinion on states' obligation under the ITLOS with regard to climate change. This advisory opinion was requested back in December 2022. Of course, this advisory opinion does not touch upon human rights because they are outside of the scope of the Convention of the Law of the Sea, but still it's relevant because it clearly states that in order to protect the oceans, states must take all available measures to cut greenhouse gas emissions which pollute the marine environment. And looking ahead, it's also worth mentioning an interesting development that we see in the African continent. In May 2025, the African Court on Human and People's Rights was asked to weigh in on states' climate obligations with the potential to further deepen the landscape of climate jurisprudence. So it will be interesting to see where this process leads to. And the three advisory opinions have been possible thanks to the leadership of a handful of states. We can mention, of course, Vanuatu, Colombia, Chile, and the COASIS, who saw the value that such rulings will bring and that we're able to mobilize the whole of the international community. Such achievements, however, were also possible thanks to the incredible efforts of the youth movement, specifically the Pacific youth and other groups that really supported them, civil society organizations. And we see that Geneva also played a very important role. The Office of the High Commission for Human Rights, special procedures, also the resolution of the Human Rights Council, the outcomes of the treaty bodies review process and general comments, all informed the outcome of these advisory opinions. And Geneva really is a fertile ground for further reflection. We have civil society organizations, but also entities like the IUCN, for instance, once again, more technical agencies like the World Meteorological Organization, UNEP, and so on. And they all contributed to a very strong outcome. And the objective of today's event is really to take stock of all of this, hear from those countries and also individuals that really spearheaded these initiatives, and reflect on the role that Geneva has played in influencing the process, but also what's the role that he has now to play to really build up what these advisory opinions said and make sure that they have an impact. We will make sure to have some time for a Q&A, so we will hope to be good moderators in that sense. And without further ado, I would like to give the floor to Ms. Merens for opening remarks. And also, may I avail myself the opportunity to welcome you officially in Geneva, since you have just recently assumed your posting. Thank you.
Thank you so much, dear Francesca. Dear Excellencies, dear distinguished delegates, dear colleagues, it is with great pleasure indeed that I have the honor today to welcome you officially to this new edition of the Geneva Dialogues. Luxembourg has been supporting this initiative since their beginning a few years ago now, and we are grateful to the organizers to continue ensuring the success of this initiative. I think you, Francesca, mentioned it as well. The Geneva Dialogues are an annual moment of reflection on the specific questions related to climate change, international law and human rights, and the role, most importantly, also in the Geneva human rights institutions in addressing these questions. Especially in today's context with the liquidity crisis, it is all the more important for us to recognize and bring forward international Geneva's role. The climate change agenda has increased over the years at the Human Rights Council, building on developments also in other fora, as for example, most of you will be familiar with the UNFCCC, the UN Nations Framework on Climate Change. The Geneva-based institutions have played a very important role in influencing the work of external processes. And as has just been mentioned, this is extremely clear also in the recent advisory opinion of the International Court of Justice, where the topic of human rights are prominent. As I was just mentioning, the advisory opinion of the International Court of Justice rendered on 23rd July is indeed a landmark or opinion in the topic of climate change. We as Luxembourg particularly welcome this important decision, which paves the way and confirms states' obligations to prevent climate harm and protect human rights. Luxembourg continues to strongly support action by the Human Rights Council on climate change, ensuring that it continues addressing important topics like loss and damage of fossil fuels. We look forward in general to very interesting discussions in this regard today. Thank you very much.
Thank you very much, Ms. Merens, and also for calling us the daunting framework in which, unfortunately, we're operating this liquidity crisis. But the hope is very much that this is not an opportunity to lower the ambition. So hopefully also a moment like this can reinvigorate our spirits to do more. I would like now to turn to Ambassador Antas. Vanuatu, as I was mentioning, has really spearheaded the diplomatic efforts that led to the adoption of the General Assembly resolution to give the mandate to the International Court of Justice. And it is impressive to note that the resolution first got adopted by consensus, but also the unprecedented number of states that took part in the proceedings before the court, whether in writing or orally. So Ambassador Antas, can you please provide a broad reflection on the International Court of Justice advisory opinion from Vanuatu's perspective? Thank you.
Thank you, Francisca. Thank you, Sandra, for your remarks. Sorry. Thank you, Francisca, and Sandro, for your remarks, and Excellencies, ladies and gentlemen, good afternoon. So today we are going to speak on the issue of the ICJ advisory opinion, which we heard was delivered on the 23rd of July 2025. For those of us who supported, all of us here in this room, who supported the work in New York, as well as made oral pleadings last year at The Hague, and when we received the results, I should say that firstly, there was a lot of lawyers speak, which in my mind, I wasn't really sure whether I had really absorbed the magnitude and the extent of the decisions that were made, or the advisory opinion rendered by the ICJ. But immediately after this, the delivery of the advisory opinion, I saw comments from everywhere, all over the world, from media organizations, those who are summarizing all this through their own knowledge. I also went through this ChatGPT to see what did they say about, what are they saying about this. Like 2 minutes later, I had a summary of that, and I was, to be honest, I was a little bit shocked to see the extent, the vast decision, the opinion that was delivered on that day. Not shocked in a sense, not shocked badly, but shocked, and I was pleasantly surprised. And of course, immediately after that, I'm thinking about the next steps, which we will discuss later on this afternoon. What happens after this? But as we know, the ICJ had rendered its advisory opinion on the obligations of state with respect to climate change in July. The opinion answers the questions put by the General Assembly, Resolution 77276, clarifying the sources and the content of states' climate-related obligations, as well as the legal consequences of their breach. If they are not following this, breaching this, what are the legal consequences? And these are very important questions. And even today, as we see it and discuss this, these have profound impact on the conversations going ahead. The opinion is groundbreaking in many respects, in line with arguments advanced by not only Vanuatu, but many of us in this room, small islands, developing states, vulnerable developing states. It confirms that every state has erga omnes obligations grounded in custom and relevant treaties to protect the climate system and other parts of the environment. That these duties must be interpreted consistently with the principle of common but differentiated responsibilities and respective capabilities. That the principle of non-refoulement applies where persons would face a real risk of irreparable climate-related harm to their right to life if returned, and that the regime of state responsibility applies to breaches of these obligations, with every breach triggering obligations of cessation, non-repetition, and full reparation. It further clarifies that once maritime baselines and outer limits of maritime zones have been lawfully established and deposited, they remain unaffected by climate change-induced sea level rise. Small islands and vulnerable developing states stand to benefit most directly from the prompt and ambitious UNGA response. We would like to provide the basis for discussion regarding this response. It must be noted that there is no formal limitations on the extent to which the advisory opinion may be discussed and reflected in other UNGA resolutions. This other part we'll discuss later on this afternoon. However, two responsible UNGA vehicles stand out as most immediately relevant for operationalizing the advisory opinion, namely a dedicated UNGA resolution to be adopted by the plenary, main resolution, and to the annual resolution of the protection of global climate adopted by UNGA Second Committee. We will discuss this at the next part of this afternoon. So I thank you very much, and I hope that gives us a summary of what we see as the main issues. And I know you all have different opinions, and we welcome all of them. I thank you for your attention.
Thank you very much, Ambassador Antas, for already touching upon some of the key elements that emerged from the advisory opinion. And we also look forward to hearing from the second panel of experts that will delve into some of the dimensions that you already touched upon. For instance, the question of reparation that is really be central in many states' arguments before the court and in the court's reasoning itself. And you did mention the question of seafood maritime zones in the context of sea level rise, and connecting it to Geneva. It's interesting to know, of course, that there's a resolution that is going to be discussed here at the Council on this very topic. So it's really interesting to see to what extent arguments from the court will be integrated in it. We now stay in the Pacific, and I will turn to Ambassador de Groom. The Marshall Islands has been vocal for decades about the need for stronger action on climate change, including, of course, here in Geneva. Ambassador, you attended the delivery of the advisory opinion in person in The Hague, and we would be happy to hear also some of your reflections from that moment. And also, if you could share your perspectives on the court's arguments with regard to fossil fuels and the 1.5-degree temperature limit, which the court touched upon. Thank you.
Thank you, Francesca, and thank you for inviting me to this very important panel discussion. And especially, I thank you for the opportunity to speak amongst a very distinguished panelists. Friends, ladies and gentlemen, good afternoon. Indeed, I had the great honor of being invited to see and to witness the ICJ verdict delivered in person just a few weeks ago. The most honest description of being there is probably overwhelming, but mostly emotional. I couldn't hold back my tears. And I wasn't the only one. To sit there and hear the world's highest court play back the very same words, the very same truth that we in the Pacific and as small island states had been speaking for so long felt almost surreal. And not just once, again and again and again, we were hearing our own words come back to us, and I'm sure it wasn't just us. A lot of us here heard our own words. Take sea level rise. For years, we've been adamant that rising sea levels can't take our territory or sovereignty. And the court agreed. Take fossil fuels, which we know we must leave behind us. The court confirmed that continuing to extract, use, and subsidize fossil fuels may all constitute internationally wrongful acts. or emissions pledges from richer countries. We've long argued that these aren't just voluntary offerings made out of charity. And the court agreed. These are legal obligations under international law. But perhaps one of the biggest moments for me was when the court affirmed the temperature limit of 1.5 degrees. For low-lying atolls and nations like ours, already handling king tides and salt water in inundation, every centimeter of sea level rising is a challenge, is a problem, and continues to be a problem today. On the road to Paris, my government numerous times invited global leaders to visit our country. And this was so that they could see with their own eyes. They could feel what we were feeling. And luckily, on one of those occasions, when those delegates landed in Madrid one summer in July, they landed on a flooded runway. And then they stood on a narrow atoll with the lagoon on one side. They couldn't believe this. The lagoon was on this side and the ocean was on that side, and they could throw rocks to both ends at some point on the island. And that certainly helped provide them with a view and a new perspective. And so the Paris Agreement included for the first time confirmation that we should be pursuing efforts to limit warming to 1.5 degrees. Now, more than 10 years later, we have heard the world's highest court confirm 1.5 degrees has become the scientifically based consensus target. Of course, we in the Pacific are probably not the people who needed to hear the court say this, because long before the IPCC was documenting the difference between 1.5 and 2 degrees of warming, we were living it. For us, the ocean is life, so we knew. But it's clear that others still needed to hear, because even 10 years on from Paris, we still hear people pushing back on 1.5 degrees as the limit. So now we can say definitely, this isn't just our view. This is the ICJ's view as well. This is the legal view. So finally, I wanted to say how thankful and proud I am of the Pacific youth that were behind this. And I thank Vanuatu and the students of the University of South Pacific for their leadership role in bringing this to the ICJ. It was a proud day for the Pacific, and if one day we can all leave our future in the hands of young people like these, I think we can all be hopeful and we'll all be proud. Modada.
Thank you very much, Ambassador. Definitely hearing your words, hope is a very shared sentiment, and I think we're all feeling. And being in The Hague must have been an unforgettable experience, but I can say also here in Geneva, many of us in the room gathered for a watch party at the Gen offices, and hearing the explanation and the presentation of the advisory opinion was really quite an experience, and I think we'll shed a tear to while listening some of the arguments. And thank you also for reminding us of the 10-year anniversary of the Paris Agreement. This is really, we hope that this strong ruling will help countries and will nudge countries better enhance their nationally determined contribution and taking a real effective action. I will now like to welcome Mr. Ruiz Botero, Second Secretary of the Permanent Mission of Colombia. Welcome. So we are now, of course, focusing on the International Court of Justice, but of course, we shall not forget the advisory opinion by the Inter-American Court on Human Rights, which saw the light also thanks to the initiative of Colombia and Chile. Looking at both advisory opinions, the question I have for you is how can these advisory opinions be leveraged in support of the Latin American region? And in what ways can the human rights-based institution here in Geneva contribute? Thank you.
Thank you very much, Francesca. Good evening to all colleagues. And thanks for your question. We were very proud of our role in requesting the advisory opinion along Chile, which is something that we did precisely seeking legal clarity on the extent to which environmental obligations, and particularly those described in the climate regime, interacted with human rights obligations. And much like the experience that Ambassador Montreal had, we were also both positively surprised and quite moved as well by the decision that was taken by the Inter-American Court of Human Rights, because it, in essence, affirms many of the convictions that Colombia, Chile, and others have been defending for decades now. Not only that states have clear obligation to prevent, mitigate, and remedy the adverse effects of climate change, but also something that's been actually in practice in my country for many years, and that is that nature and its components are subjects of rights as well, which is strong innovation in international law and something that we do think is important to build on, both in the work of the Human Rights Council and other human rights-based institutions, but evidently as well in the climate regime itself. We were also very happy to see a role that is clearly recognized of vulnerable groups, the importance of intergenerational equity, the importance of indigenous peoples in particular, but also people of African descent, peasant communities, and those that hold traditional and indigenous knowledge, which is crucial to responding to the challenges of climate change. This particular opinion for us has very important value. I think the president of the court said it best. It's no longer a moment where we can have any room for indifference. That's a clear message to all those who are bound by the San Jose Convention and the Inter-American regime at large, which sadly has not been necessarily the region where compliance with climate obligations has been the strongest. And I think that has great value. But I also think that, and this is something that the Inter-American Court has done quite a bit in many areas of human rights, it's going to be an important tool to drive progress on how we develop the law on international human rights and interrelation change. As regards the work in Geneva, I think it's not going to be a surprise to many, but we have been very disappointed by the extent of the work that has been done, particularly in the Human Rights Council. And so the discussion that we were having before on the 1.5-degree targets, the discussions on fossil fuels, the discussions on what are the implications on human rights of climate change obligations, have all been, in essence, been swept under the rug in our discussions in the Human Rights Council, much to our chagrin and against our quite loud protestations, I would say. This is, we think, an important moment as well to remind all of us that that needs to change. And my country certainly intends to ensure that the way that we tackle climate change and the Human Rights Council from the next session on does change. And we think it's important that those use conscience obligations that are set out in the AO of the International Court of Justice are clearly expanded upon, not expanded upon, but elaborated upon in a Human Rights Council resolution. And we would be very happy to work on this as soon as possible. Thank you.
Thank you very much, Mr. Ruiz, and definitely well noted about expectations for the Council. If I might say, the Human Rights Council has played a very central role in infusing the UNFCCC process, the Climate Convention, with human rights language. So we really hope that it will be able to now build on, as you say, what the court has said and really further elaborate on it. There is the capacity, the political will is what has been missing so far, but hopefully conversations like this can shake things up. Now over to Ambassador Antas. You mentioned some next steps diplomatically. Now we have the General Assembly that have received the advisory opinion of the International Court of Justice. So what are you envisioning in terms of next steps at on the international arena?
Thank you. Before I respond to that, I want to say is that the international scenario that we had in July, since July, August, now September, things have changed and will continue to change. So it seems to me that even whatever I say next, it will be determined by what happens in the global agenda. We, Vanuatu, and hopefully many of the states, see that the diplomatic next steps are fundamental in implementing the advisory opinion. And I will share some thoughts on how this can be holistically be approached. Firstly, states remain at the center of implementation of the UN system. The ICJ confirmed that failure to regulate emissions caused by production and consumption, provision of subsidies, fossil fuel licensing, and the lack of regulation around private actors within states' jurisdictions or control can constitute international wrongful acts. The UN General Assembly will be the first arena to translate this clarity into actions. There are two opportunities for resolutions of the UNGA to support implementation of the advisory opinions. One, as is normal practice, a dedicated resolution from the UNGA on the advisory opinion will follow, hopefully as soon as possible. We hope that this resolution will not only welcome and endorse the opinion, but recognize the contributions of the other climate opinions, strengthen linkages to human rights mechanisms and protections, and establish mechanisms and measures of fossil fuel phase out, finance and capacity building, maritime boundary protection, and pathways for preparations grounded in the duty of cooperation, CBDR, and equity. And as I had mentioned earlier on, because of the global international framework is slightly not the same as what we had in July. Our view that was expressed 2 weeks ago in Vanuatu was that we are going to go back into alliance then. To have the negotiation, the next round of resolutions is going to be very difficult. It will entail a lot of work. But if we remain committed to, as we had done last year, then we can get some results. But our ambassador in New York reminded me about 2 weeks ago that this is going to be a very difficult work. And if we continue and commit ourselves to the common good, then we can extend the work and hopefully there are some results from that. Secondly, there is a key opportunity to maximize the impact of the advisory opinion. We have to do that. We have to maximize the impact of the advisory opinion and ensure that structural change needed to move us beyond the limitations of the consensus-based decisions on the climate regimes and operationalize the climate justice based on the rule of law and equity. And it must be advanced while we have momentum and before COP30. The annual resolution of the protection of the global climate, scheduled for December this year, is another opportunity to embed the court's contributions to the UNGA ongoing climate practice, universalize the opinions, conclusions, and signal political support for their implementation. There is another opportunity to correct the current limitations of these annual resolutions by achieving climate action is not only grounded in environmental treaties, but also human rights, for example. We states need to ensure that we are advancing the diplomatic support to mandate and engage the UN bodies, to embed the legal findings in the resolutions, periodic reviews, continuing monitoring how climate inaction translates into violations of rights to life, rights to health, rights to food, water, and culture, and providing authoritative guidance to states in compliance with human rights-based obligations. We need to mainstream the operationalization of the advisory opinions through the UN bodies here in Geneva. Can we do it? Will we do it? And also in New York, and also in our own homes, in our own countries, to ensure that the protection and respect for human rights are central to the mandates, mechanisms, and measures strengthened or established. These resolutions are key to making this happen, and we look forward to collaborating with states, UN bodies, and mandate holders and CSOs. Our non-government organizations, which are very important on the initiatives for the resolution as they progress. That is all I can say. Thank you.
Thank you very much. It's very interesting to hear about initiatives around the GA, but also this dual approach to keep the focus both at the General Assembly and the Human Rights Council. And talking about the Human Rights Council, over to you, Ambassador De Broom. What are the next steps at the diplomatic level that you are envisaging here in Geneva specifically?
Thank you, Francesca. As you know, we have recently begun our second term as a member of the Human Rights Council and one of only 4 SIDs on the council, and the only Pacific state on the council. So we take these responsibilities very seriously. And the sad reality is that for many islands and coastal communities in all parts of the world, the enjoyment of many human rights is tied to climate change. And it was important for us to hear the ICJ confirm that too. The court described in great detail the link between human rights and climate change, including the threats that climate change poses to, as Ambassador Antas mentioned, the right to life, the right to health, the rights of women and children, the rights of indigenous people, amongst many others. So I think the first thing we can do is feel emboldened in our convictions. Anyone who does not realize that there's a role for climate discussions in the Human Rights Council is welcome, and I invite them to please take a look at the ICJ decision. And not just read it, but understand it. And together with us, embrace it. Because it's time for all of us to get to work. We can't do this alone. We need everyone on board. We are immensely grateful for the great work of the Special Rapporteur. And I'm looking forward to hearing her views on how the decision will influence her work. And of course, this session, we're particularly looking forward to seeing a resolution come forward on sea level rise, which can immediately make use of the ICJ's conclusion there. We thank the Dominican Republic for taking the pen and for their leadership on that effort. Many of you were here in the 59th Human Rights Council when we had negotiated the text of the climate change resolution to have it make reference to the efforts to move away from fossil fuels. Although we were able to negotiate a strengthened text, we didn't secure everything that we had proposed. And I know many of our allies would like to even go further. We will continue to advocate for a strong text, and next time it comes around at the council, and you can rest assured of our commitments to approaching things constructively and boldly to make sure to defend the interests of those most vulnerable. We have a wonderful cross-regional network of ambitious states here in Geneva, developed and developing countries from north and south across regional groups. So I know the Pacific and the small island developing states won't be the only ones stepping up, which is important because we have some of the smallest delegations trying to cover multiple mandates, trying to cover the entire Europe all at once. But armed with the ICJ decisions, we are confident that we will see the Human Rights Council reach new levels of ambitions. Again, como dada, and I thank you.
Very much, Your Excellency, also for calling the upcoming sea level rise resolution, and we really look forward to engaging in it. I'm unfortunately conscious of time, so we're slowly coming to the end of this panel. Mr. Ruiz, the next panel made of experts will look at specific elements and arguments from the advisory opinions. And some of these elements, which also have been mentioned on this panel, are remedy and reparation. Now that these arguments are out, we will be keen to hear your thoughts on the ability of frontline nations and affected communities to secure remedy and reparation in the face of climate harm. Thank you.
Thank you very much, Francesca. And I don't want to speak too much on this because I'm sure we'll hear more interesting stuff on the second panel. But when it comes at least to the inter-American system, I think there's a couple of things that are important. The first is that this advisory opinion should trigger an obligation for states to make sure that these remedies are available at the national level by domestic courts to make sure that they are protected and that potentially then if they aren't available, that would bleed over to the internal system. One thing that we thought was particularly important was the emphasis that the court put on the differentiated obligation to protect communities that are most impacted by climate change. And we think that will potentially help frontline communities to make sure that their rights are protected at the national level. We also thought it was very interesting how the court phrased its reference to the regulation of private actors. And not only mentioning the importance of licensing and taxation and contributing to transition, but potentially also ceasing operations and demanding reparations for actions that would go against the human rights of both frontline communities and individuals. And so we do think that there are very important tools there for frontline communities and individuals, at least in the inter-American system, to use going forward. And as I said, generally it is the way that the inter-American court shows the way and the multilateral system follows. But when it comes to the more general picture, particularly when it comes to frontline nations and vulnerable countries and developing countries in general, we do think it's also an important step towards having a more sincere conversation on the importance of financing on the importance of addressing loss and damage clearly. I don't think it's a surprise to anyone that developing countries were very disappointed at our discussions on the NCQG and our discussions in financing in general. We're also quite disappointed at the progress that has been made on the loss and damage fund. And we do think that it's very important to make sure that now that the legal obligations are clearer, we also act upon those in the climate negotiations in full knowledge of what they are, but also how they interact with the rest of the obligations of the climate agreements as well. And those, of course, related to the differentiated obligations with regards to financing, capacity building, technology transfer, technical assistance. Because it is very difficult, particularly for developing states, to ensure that they are complying with these obligations as best as they can when there is not as clear a compliance from developed states with their financial obligations under a climate regime. That's one thing. And the other thing, and it's kind of the other side of the coin, is that we do think that the advisory opinion of the ICJ also takes away from the argument that we hear very much from other fellow developing countries that we don't share, and it's that financial obligations have a primacy over regulatory obligations. And so that we need only comply with the regulatory obligations when we do have those means. And evidently it is clear that that is incorrect, both legally, but also morally speaking. And so we will be making that point, and I'm sure that there are many countries, both in Latin America, friends from the Pacific states, that will be driving that home, hopefully making sure that the law also reflects the conversations that we have in our negotiations as close as we can. Thanks.
Thank you very much, Mr. Ruiz. I think this is a perfect segue to introduce the new panel, which will delve into more detail across different dimensions, including professional climate finance, remedy, redress, also looking at the COP. Without further ado, I would like to thank once again our distinguished panelists, Ms. Nayans, Ambassador Antas, Ambassador De Broom, and Mr. Ruiz for their time and contributions. We have now to unfortunately shift the panel. So I would like to call to the podium my colleague Joy Chiduri, Senior Attorney at the Center for International Environmental Law, who will be moderating the second panel. So Joy, I will pass the baton to you, and I will let you introduce the new panel. Stay with us, and then looking forward to continuing the conversation. Thank you very much once again. Yeah. Here.
And I want to find Jesus. Sorry, just have to give the good example. Thanks, Anna Maria. Sorry. Here we go. All right.
Is this
Maybe somewhere.
there?
Yes. Here.
But here, there's nobody there. It's Joy.
Ah. Perfect.
Lisa, is this yours?
The water, I haven't touched yet.
No, no, is it yours?
Yes,
Just
so you can go for that.
so I don't steal yours. That's not.
Access to water is guaranteed.
I'm very tempted. You gotta move this away from me.
I will not. If people go over time, I will do it. Just to. Oh, okay. Or, all right, what is our time? 5 minutes or?
5 minutes for the first, maybe 2 or 3 for the second.
Okay.
Good afternoon, everybody. We are going to start with the second panel now. My name is Joey Chowdhury, as my colleague introduced me, and I'm also from the Center for International Environmental Law. Many thanks for the rich contribution of our first diplomatic panel. And we are honored to have with us today a distinguished panel of experts as well, deeply knowledgeable about the historic climate advisory opinions that we have received from the International Court of Justice, the Inter-American Court of Human Rights, and the International Tribunal for the Law of the Sea. And they will share their critical reflections with all of us. I will introduce them as they begin their interventions. But before we start with the specialized and focused interventions, a few brief overarching framing remarks. And the climate advisory opinions is a turning point in terms of climate justice and human rights because it provides a definitive pathway to move beyond the vague promises and the voluntary pledges that we hear across fora and ground much needed climate ambition in legal obligation. And the 3 tribunals that were discussed in the panel before, they've delivered now unprecedented legal clarity on states' obligations in relation to climate change, spotlighting in particular climate destructive corporate conduct, providing a robust legal blueprint to hold polluters accountable under multiple and complementary sources of international law, putting the weight of international law behind just and equitable climate action. And they have done so on the basis of existing legal norms, reflecting also the emerging jurisprudence in other regional and domestic cases. These rulings did not come in a legal vacuum. We are seeing over the last years the counters of a growing body of climate jurisprudence, a mosaic of legal reasoning that could redefine climate governance for generations. Advisory opinions are authoritative interpretations, as we know, of binding international law. The reasoning put forward in the recent climate advisory rulings can be invoked in courts across a variety of cases, shape, as we've heard, the direction of climate negotiations, and inform national legislation and policies. And this work has already started. To cite just 2 instances in relation to the ICJ advisory opinion, and there are several already, there have been the use of arguments based on the ruling in a legal appeal against offshore deepwater drilling, and a recent declaration endorsed by 22 countries in Latin America and the Caribbean expressing support of COP30 and making clear reference to the ICJ climate advisory opinion. The questions before the court were never theoretical ones, but they addressed legal violations deeply affecting peoples and nations across region, and thus are fundamental as a foundation for ambitious and just climate action. So whether it's implementation through litigation, diplomacy, or campaign pathways, this phase, as was made very clear by the panel before, this phase of implementation is a critical test for all of us. So as we're discussing today, and our distinguished panelists will provide more light on, what role can UN Geneva play, the Human Rights Council, but also the UN treaty bodies, the special procedures, the specialized agencies, and others? This is the critical question to answer today. The second Secretary General of the United Nations, and I may not pronounce his name correctly, Dag Hammarskjöld, he once said, everything will be all right, you know when people stop thinking of the United Nations as a weird Picasso abstraction and see it as a drawing they made themselves. When you go to the front lines, the UN is often something very far off, but we have seen in many cases where movements have approached the UN by different pathways for redress. And in the case of the ICJ-AO, as we know, the students from the Pacific saw the climate devastation all around them and the lack of a sufficiently ambitious response, and they decided to approach
the principal judicial organ of the UN for support, and they galvanized their states, and there was a lot of diplomatic coordination, and there was a lot of support from the UN. Many of you in this room, in your different capacities, this bridge between institutions and people is critical to breathe life into normative work for standard setting to have tangible effect. And finally, let us remember the remarkable alignment on climate justice shared by the vast majority of delegations that were arguing before court. And this alignment is one that we must continue to build on. And at the heart of the Inter-American Court of Human Rights advisory opinion and the ICJ advisory opinion proceedings were people's movements whose vision and analysis brought a deep climate justice lens to both processes. And in the ICJ case, we must highlight the steadfast leadership, as was mentioned several times, of the Pacific youth and the global young campaigners, particularly our colleagues from the Pacific Island Students Fighting Climate Change and the World's Youth for Climate Justice, whose unwavering dedication from the case's inception made this powerful result possible. Their commitment to justice has been extraordinary. So with this, I turn to the incomparable Jule Schackenberg. Sorry, Jule. And she is the executive director of the World's Youth for Climate Justice. And Jule, we wanted to ask you to share your reflections on the role of youth in shaping international law and climate action. Over to you.
Many of you will have heard the story, the incredible story of how young law students from the University of the South Pacific approached Vanuatu's Honorable Minister Regan Vanu in 2019. Asking the government to take the world's biggest problem to the world's highest court. It is worth taking a moment to remind ourselves of why this case was brought in the first place. It was the insufficient results from the global climate regime and the lived experience of climate harms by young people in the Pacific and around the world and by communities that have propelled these young people and states to look for solutions in the law to unlock this gridlock. What you might not have heard yet is that it was young people around the world who had engaged with governments and, when necessary, put some external pressure on governments around the world to support the resolution in New York. It was young people who had reached out to ministries and legal counsel, actively supporting the process of drafting submissions and collecting testimonies and sharing resources with drafters. I'm not saying this to toot our own horn, but to express gratitude to those of you who have received youth with open arms in offices and in front of conference halls and sometimes in coffee shops, to hear us truly, and to share that youth and our friends from civil society stand ready to mobilize around the implementation. We collectively fought for this climate ruling, not to remain, and as Joy said, an abstract legal conversation, but to truly push and pull national lawmaking, multilateral negotiation processes, and litigation efforts. And this has already started. Our youth campaigner, Prajwal in Nepal, has been asked to hold a workshop for judges of the High Court to share with them what the AO means on a national level. We have a youth campaigner based in the Philippines who's been asked advice on the loss and damage policy that the Philippines are working on. I'm also telling you this today because there's young people in every country around the world wanting their governments to take more action on climate change. Therefore, if you work for a state or with a state, with a COP delegation or here in Geneva, do not forget why this case was initiated and who it was meant to serve. When considering your national level implementation, I invite you to consult your youth and human rights groups. As we already heard today, the court truly listened. Cynthia, one of the 27 law students from the very first day from the Solomon Islands who had joined the oral delegation of the oral submissions delegation of the Melanesian Spearhead Group, in her oral remarks, she told the court not to make the Paris Agreement a safe harbor for polluters, a trap for everyone else, but rather an instrument of hope. And the court truly listened. It was youth and the civil society movement together with, of course, the strong leadership from civil society organizations in the Pacific, together with states that had managed to depoliticize the case and raise the profile of this case to one that was truly about the most affected people. When you ask me about reflections of how young people shaped international law and climate action, I will say that despite all odds, and there were many, young people managed to produce a truly historic advisory opinion. And now it's on all of us to produce what the youth, including these 27 law students and everyone who joined them, were seeking from this effort. And that's climate justice through more ambition and accountability.
Sorry. Thank you so much, Yulev, for these powerful reflections. And the role of youth has indeed been central to this powerful, transformative ICJ advisory opinion that we've had. Also, there have been many states that have put in such incredible work to make this outcome possible. And one of the leading states has been Vanuatu. And there's been frontline nations from across the Pacific, the Caribbean, Latin America, Africa, across Europe as well. There have been many countries who have shaped that. And now we will listen to Margareta Weberinke Singh, who was legal counsel for Vanuatu and an associate professor of sustainability law at the University of Amsterdam. She has been at the heart of the legal strategy around this case. So now we'll turn to the video statement from Margareta.
Thank you to the organizers and co-sponsors and to colleagues gathered here at the Palais. It's a pleasure to contribute to a conversation that sits at the heart of Geneva's mandate, protecting human dignity by giving legal effect to science, equity, and justice. Over the past year, 3 landmark advisory opinions have clarified states' obligations on climate change. Together, they confirm what this community already knew and affirmed at countless occasions, that protecting the Earth's climate system and safeguarding human rights are not parallel projects. They're interdependent and intertwined. The International Tribunal for the Law of the Sea held that anthropogenic greenhouse gas emissions constitute pollution of the marine environment under UNCLOS, and that states must exercise stringent due diligence to prevent, reduce, and control such pollution. The Inter-American Court of Human Rights has clarified states' human rights duties in the climate emergency, including with respect to future generations, the right to a healthy environment, and access to justice and remedies. The International Court of Justice most recently confirmed that a clean, healthy, and sustainable environment is protected under international law, and that human rights law must inform states' implementation of their climate obligations. Where wrongful acts occur, the well-known consequences of state responsibility follow, including cessation, guarantees of non-repetition, and reparation. Geneva's institutions, including the Human Rights Council, its special procedures, and the treaty bodies, helped make these outcomes possible. Several Geneva-based contributions were cited and relied upon in the advisory opinions. They now provide a ready-made foundation for implementation. If we are serious about remedy and reparation for climate harm, Geneva can lead in at least 3 ways. First, treaty bodies should systematically integrate the advisory opinion standards into concluding observations and views, insisting on concrete preventive measures, such as on the regulation of licensing and subsidy regimes, as well as remedies where rights have been violated. Second, special procedures, working with IACtHR, can develop practical guidance on climate-related remedies, how to assess loss and damage in human rights terms, how to operationalize procedural rights in the design of remedy frameworks, and how to secure remedies across borders. Third, the Human Rights Council can consolidate these developments by mandating an ongoing work program on human rights-based remedies for climate harm, grounded in the advisory opinions and the latest science on risk and attribution. All of this would directly contribute to the UN General Assembly's work on climate justice, which will be carried forward in a resolution following up on resolution 77/276 and the ICJ's opinion. Together with human rights bodies' contributions, the advisory opinions have given us a coherent legal compass. Geneva has the tools and the responsibility to ensure that compass guides concrete outcomes. Those who bear the brunt of climate harm deserve nothing less than decisive collective action on implementation. Thank you.
Many thanks to Professor Margareta Weberinka-Singh for those reflections. And the two advisory opinions from the Inter-American Court of Human Rights and the International Court of Justice have really reinforced the legal architecture we have to secure remedy and reparation for climate harm. UN Geneva institutions have already built a strong foundation, a normative foundation for this work, and can now build on this further. We will now turn to Professor Jorge Vinuales, who is a professor at the University of Cambridge and also legal counsel for Vanuatu and the Melanesian Spearhead Group. Professor Vinuales, our question to you would be, the International Court of Justice has highlighted the importance of cross-fertilization across many bodies of law, as well as between treaty law and customary law. And this harmonious interpretation approach is particularly relevant for Geneva human rights institutions. Can you tell us what the implications are for mechanisms in UN Geneva?
Thank you very much, Joey, and thank you very much for the kind invitation. It's a pleasure and a privilege to be here. In simple, I think that there are two main takeaways that are very important here. The advisory opinion removed the lock that was placed on climate change, and that even in the work of the Human Rights Council, in the very first resolution about human rights and climate change, always stated that the issue of climate change has to be handled in the climate change negotiations that are subject to the consensus rule and that are highly politicized, particularly in the last few years. So right now, the court simply has said, all fora are open. And particularly, and that's the second part of the issue, I think that the human rights focus is extremely important. I would say it's the most important one of all the different forums or fronts that the advisory opinion has opened. And the reason for it is very simple. If this advisory opinion is going to be implemented beyond the politics, it's going to happen through courts. And it's going to happen mainly through domestic courts. And the main body of international law that is applicable in domestic context is human rights. And human rights, from that perspective, become the central battlefront in a way, particularly in the context of the Geneva institutions, to some extent in the Human Rights Council, but I would say much more in the treaty bodies and the special procedures, because this is where the actual detail of human rights is being developed and fleshed out. And just to conclude with this very brief observation, something I have not seen discussed in any detail in most of the contributions in writing that follow the advisory opinion is the fact that because the advisory opinion was rendered unanimously, the declarations and the separate opinions of the judges, well, they are extensions, they are not contradictions with the body of the advisory opinion. That means, for example, that something that has not been achieved politically, which is the content of the right to a clean, healthy, and sustainable environment, is now fleshed out to some extent in the advisory opinion and to a greater extent in the separate opinion of Judge Charlesworth. So this is, the advisory opinion is the entirety of the 133 pages of the opinion and the 130-something pages of the declarations and the separate opinions, because it is unanimous. So that's really a turbocharging climate litigation.
Thank you very much, Professor Vinuales, for that very rich and precise intervention, also for the concrete examples that you provided. Ben, turning to you now, I would like to follow up on what Professor Vinuales mentioned on the right to a clean, healthy, and sustainable environment. The court emphasizes the obligations under international law of states related to the human right to a clean, healthy, and sustainable environment. Geneva has done a lot of work on this. How do you think Geneva institutions, in particular the Human Rights Council, could build upon this reaffirmation by the court to ensure effective protection of this work, building on what Professor Vinuales just mentioned? And sorry, Ben, I'm so sorry. This is Benjamin Schachter, which I think goes without saying. All of you know him in the room, and he is the coordinator of the Environment and Climate Change team for IACtHR. Sorry, I forgot to introduce you. Please go ahead.
That's quite all right. Thank you. And first of all, welcome everybody. And we're so pleased to be here as a co-organizer and participant in this discussion. You know, the push for recognition of the right to a clean, healthy, and sustainable environment was a long one, and one that involved a wide range of states and civil society organizations and indigenous peoples representative organizations and other stakeholders. And it is incredibly validating to see that the ICJ and the Inter-American Court advisory opinions both reaffirm the right to a healthy environment and elaborate on it in important ways. It's very clear, I think, from these opinions that the discussion around the right to a healthy environment can only move forward in the direction of implementing it. Its existence, etc. I think it's a closed book. The ICJ advisory opinion is also very clear on the fact that there is a duty to protect the environment under customary international law. And as Jorge references, there are a number of separate opinions. Some of those separate opinions express the desire of particular judges for the unanimous body of the decision here to have gone even further in terms of articulating the right to a healthy environment and explicitly declaring it, recognized under customary international law. But I think he's right in saying we should interpret all of this collectively and in light of the broader body of law and of the findings, of course, of the ICJ itself, that the right to a healthy environment is implicit and inherent to all other rights and their effective enjoyment. It's a necessity for that, and that really, we now have this opportunity to move forward into implementation. So the court says, for example, environment is a precondition for the enjoyment of many human rights inherent to the enjoyment, and concludes that under international law, the human right to a clean, healthy, and sustainable environment is essential for the enjoyment of other human rights. That's from the ICJ AO. The Inter-American Court AO goes into even more detail and also articulates the right to a safe climate as an element of the right to a healthy environment. And I'll just say in terms of the way IACtHR and other partners we have, including within the UN system, so IACtHR, UNEP, and UNDP have articulated the elements of the right to a healthy environment. That includes a safe and stable climate, healthy ecosystems and biodiversity, a non-toxic environment, clean air and water, and participation, access to information, access to justice and environmental matters, and a wide range of other interrelated and interconnected issues. Safe and nutritious food, I believe I erroneously left out there too. But the point is, everything is moving in the same direction with the right to a healthy environment, and this is a further step. And the other thing I would highlight is that the courts, both the ICJ and the Inter-American Court, have drawn extensively on the work of international human rights mechanisms here in Geneva, the human rights treaty bodies, the Human Rights Council, the special procedures mechanisms of the Human Rights Council, the work of the Office of the High Commissioner for Human Rights as well, which has been mandated in this area by a series of resolutions over more than a decade. And seeing that and seeing how the court really builds on all of that work and synthesizes it, I think it's very clear that we have a consensus around the right to healthy environment, and as I said before, need to move forward with the implementation. Thank you.
Thank you so much, Ben, for those very powerful remarks and reminder of how critically central the right to a healthy environment is, how much consensus we have behind it, and how important now implementing this further and in our territories, in our regions, is vital. We will now turn to Professor Elisa Morgera, Special Rapporteur on Human Rights and Climate Change. One of the most fundamentally pressing issues in climate action is the just and equitable phase out of fossil fuels. And the ICJ advisory opinion contains strong language on fossil fuels. In light, Elisa, of your recent report on the imperative to defossilize the economy, could you please share your reflections on the court's arguments on fossil fuels? Thank you very much.
Yeah, thank you so much, Joy, and it's a pleasure and an honor to be here and indeed starting, I think, a reflection on that groundbreaking clarification of the International Court of Justice, not only explicit but extensive clarification that not only the consumption of fossil fuels, which for a long time we know is the main cause of climate change, but also the production, the issuing of exploration licensing, and subsidies are maybe internationally wrongful acts. And that to me is, there's many layers, I think, of legal importance of that clarification. I mean, there's an immediate layer, I guess, of political relevance, and it relates to what we've heard from the diplomatic panel about how difficult it has been for decades within the climate system regime, but also very recently here at the Human Rights Council to mention explicitly the main cause of climate change and what should be priority climate action to effectively prevent further harm to the climate system and further harm to human rights, and particularly the human rights of individuals, peoples, entire countries who have already for over 10 years been bearing the brunt of catastrophic climate impacts. What I find very important about that clarification, and we had some references to fossil fuels also in the Inter-American Court, but not quite with the depth, extensive legal clarifications of the International Court of Justice, is placing the phasing out of fossil fuels in the broader context of those obligations of prevention, strict due diligence, and stringent due diligence obligations that each of the three advisory opinions have clarified, that essentially clarified state obligations are obligations to protect the life supporting systems, including the climate system on our planet. And so a much broader, deeper clarification, both of what is at stake and what has been sacrificed time and again and is still sacrificed by unambitious or obstructive conduct by states and business enterprises, but also placing an understanding of the phasing out of fossil fuels beyond an energy transition. Of course, we need phasing out of fossil fuels within the energy sector, but as my report here to the Human Rights Council emphasized, this is not the only place where fossil fuels are hiding in plain sight. And in fact, the fact that they are expanding, notwithstanding that scientific consensus around their being a main cause of climate change, has to do with almost all other sectors of our economy that are linked to plastic production, that are linked to petrochemicals, and that effectively not only further contribute to climate harm, but give rise to a whole other series of human rights violations that arise from damage to ecosystems that contribute to climate regulation and damage to all the natural processes that sustain human resilience to climate change. So I think that broad understanding, which we find coherently clarified in all the advisory opinion, is essential to then understand the obligations that arise from that recognition of internationally wrongful acts. And maybe just to then capture a couple of additional points in terms of how we then need to implement the phase out in accordance with multiple complementary international obligations arising from different sources of international law. And that is the case of customary law, treaty law in different areas, and particularly thinking about the interactions, the interdependence of the human rights that are affected by climate change, as it has been documented for over a decade here in Geneva. And that is essential to understand which action can be most effective in the phasing out and in protecting human rights, thinking about the right to life, the right to health, the economic, social, and cultural rights, but crucially the right to self-determination, which has jus cogens nature, and the prohibition of racial discrimination, which again has jus cogens nature. And that reflects those very bold findings by the Inter-American Court, and I think needs to be also a guide for thinking about reparations, and I'm closing there. And the argument I made in my report here to the Human Rights Council is that reparations and the human right to remedy, implementing those related obligations is essential to create a space for reclaiming self-determinations for the countries, peoples, individuals who have been most affected by climate change. And it's an essential space for all of us to be able to transform our economies, moving away from fossil fuels, leading towards a life that's fossil fuel free, that's healthy, and that supports the full realization of everyone's human rights.
Thank you very much, Professor Morgera, for those very important and necessary remarks, because right now, this is the fight of our generation. Thank you very much. I will now move to Ana Maria Suarez Franco, who is the International Secretary General of FIAN International. She has been an unwavering voice on corporate accountability in Geneva for many, many years. Could you share with us some reflections on the corporate accountability dimension in the advisory opinions, and how can the legally binding instrument on transnational corporations build on these advisory opinions?
Thank you very much, Chloe, and all the panelists. It's extremely interesting. Also, thanks to the co-organizers. First of all, I want to highlight that this is a very relevant question because the corporations are part of the problem that we have with climate. In the area FIAN is active, they contribute, the industrial food system contributes to a third of the greenhouse emissions. As Elisa said, it's not only the energy sector, it's also the food sectors and others. And therefore, if we want the transitions to be just, they have to include corporate accountability. This is also very important for many of the grassroots communities we support. Most of them are affected by corporations. And there are cases that originally are on the right to food include environmental dimensions connected to the triple planetary crisis. Interestingly, the advisory opinions make very clear which are the obligations of the states and emphasize on the obligations to protect and prevent, as Elisa said, relating to the environmental harm and the climate change in connection with the right to clean, healthy, and sustainable environment and with other human rights. And we already had jurisprudence from the International Committee on Economic, Social, and Cultural Rights explaining that the obligation to protect includes to regulate, monitor, investigate, and enforce and provide remedy for the actions or commissions of non-state actors under their jurisdiction and control. And the advisory opinions depart from this basic legal standard, but go further in clarifying how they apply to climate change and other kinds of environmental harm. The ICJ takes an approach, and it is mainly focusing the obligation to prevent or protect on states' due diligence, which, as Margareta said, is a stringent due diligence. It is very important to clarify that in the legal world now we have different understandings of due diligence. We have the classical Roman law one, which is the conduct of the good pater familias, but we also have the UNGPs, which have a kind of, in our assessment, weak view, and it is about due diligence of companies, but here we are speaking about the due diligence of states to regulate and to prevent. And very importantly, the court says that the due diligence should be based on the precautionary principle, which means it's not like let companies do to see what happens. Maybe there is a risk, maybe not. The court says very clear, if there is doubt, precaution is ordered, but also risks assessment and also consultation and notification when the activities of a state or a company under its jurisdiction or control can affect these other states. And this is very important because it reaffirms the relevance of extraterritorial obligations of the states in the field of environmental law and human rights connected. So very importantly here is to see how the International Court of Justice takes this approach, giving us a good soil that will be developed also by treaty bodies and special procedures, as I will explain in the next question. The Inter-American Human Rights Court goes a step ahead because it directly refers to the obligations of corporations and their accountability. And it says that the court recalls that states must adopt legislative and other measures to prevent human rights violations committed by state and private corporations. And there are many paragraphs referring to this, but I would like to emphasize that it refers, of course, also to the importance of enforcement. This is also in the part of the ICJ, but also mentions that it's very relevant that the states adopt a series of the standards to discourage greenwashing and undue corporate influence in the political and regulatory sphere. In this area, we know that companies, and especially the oil companies, have been influencing a lot the negotiation of regulatory standards, and it has been very difficult to avoid this corporate culture. So this is very relevant. I would like to finish, sorry for the time, saying that all these paragraphs, and we can speak later in the discussion about them, are important inputs for the ongoing process on corporate accountability, on a treaty on TNCs and other business enterprises with respect to human rights. In the Human Rights Council, we have had the right to healthy environment inside, then some states have put it out, then civil society brought, and other states brought it again. I think now we cannot escape anymore because the legal standards are very clear on the relevance and also other environmental elements that the different articles of the treaty should cover. And FIAN with Friedrich Ebert Stiftung, in cooperation with the International Service of Human Rights, CIEL, IACRnet, and Franciscans International, will issue a paper analyzing how this should be reflected in the treaty text in October. Thank you very much.
Thank you very much, Ana Maria, for those very comprehensive and critically important reflections on the ties between the historic advisory opinions and the corporate accountability. And I am going to also turn to Professor Vinualis. We're going to enter a second round of quick questions, but we will keep our comments shorter so I'm able to provide some room for questions as well. So to all of the panelists, we will come to each of you with a second question. So turning to Professor Vinualis again, the International Court of Justice was very strong on the duty to prevent significant harm to the environment and due diligence. And Ana Maria has elaborated already on some of this, but are there any elements that you'd like to add, also considering your own striking submission during the Vanuatu and MSG joint intervention at the ICJ hearings? And of course, please feel free to draw from the other advisory opinions as well.
Yes, thank you very much for it. It's an important question, I think. Let me start with what the court said would be a wrong conclusion. And this is important to state at first, because it had been very widely argued, both in the ITLOS advisory opinion and during the written and oral submissions. There were a number of delegations actually arguing that if you meet one obligation, you meet them all. Essentially, you meet the Paris Agreement and you tick all the boxes at the same time. A more nuanced and perhaps more acceptable for the court, but still a banana skin, I think, position was to say that by meeting one obligation, you create a presumption that you have met some other obligation. But the court, to some extent, took that banana skin, to some extent, but with two caveats. So first, the court stated very clearly, even quoting the ITLOS advisory opinion, that obligations are separate. So if you meet the requirements of one obligation, whether human rights, customary international law, the law of the sea, elsewhere, you're not necessarily by that meeting the requirements of a different obligation. But the court was very clear on that point. And then on one specific relationship, that is between the relationship between the climate change treaties that the court characterized as the UNFCCC, the Kyoto Protocol and the Paris Agreement, and a very specific customary international law norm, the principle of prevention of significant harm to the environment, which is no longer now called no harm, thankfully. The court said, in principle, if you meet the obligations under the climate change treaties, as the court has interpreted them, and that caveat is very important, then that would be a strong indication that you're displaying the stringent due diligence required by customary international law. But that's two steps that are very important. First, only if you're meeting the Paris Agreement and the other climate treaties in the way that the court interpreted them, which is a new way, which is a much more genuine way, much closer to the spirit of Paris than to what Cynthia actually said during the pleadings, like a trap for everyone else. So that's very, very important, and Judge Tladi mentioned that and saying this is very important. The court is not saying that if you meet the Paris Agreement, you have some safe conduct that allows you to go through customary law unharmed. It is the Paris Agreement as interpreted by the court. And second, it's just an indication. So that's the relationship that has to be very fully understood. because otherwise any obligation, meeting any obligation, means meeting any other obligation, and that cannot be true.
Thank you very much, Professor Viñuales, for those very thoughtful comments and how we should be reading the law as well, which is always very critical. I will now turn to Benjamin Hector again. And I'm sorry to do this to you, Ben, because I'm going to ask you a very big question in a very short amount of time. The centrality of science. We've heard about the fight for 1.5. It is a red line, and we know that 1.5 itself is not safe, that many of our countries and regions are facing horrific levels of climate devastation at this. The centrality of science was clearly affirmed by the courts in guiding states' action on climate change. How can human rights mechanisms build on this?
Yeah, well, first maybe I can build on something Jorge just said about how we need to interpret the Paris Agreement and its goals in line with the court's means of interpretation. And I think it's very clear from both the Inter-American Court advisory opinion and the ICJ advisory opinion that science, the best available science, which is talked about repeatedly in the Paris Agreement itself, but also the right to science, which is the subject of an extensive portion of the Inter-American Court advisory opinion, needs to guide our interpretation of the treaties and their obligations and commitments as a whole. So we also, I think, need to factor into that the objectives of the UNFCCC and of the Paris Agreement, including the protection of human health and welfare, sustainable development, the eradication of poverty, the commitment of the preamble of the Paris Agreement to respect, promote, and consider human rights. I think you look at that all together, and it's very clear that science should guide our overall level of ambition. And that's an argument that we've been advancing in the human rights community for many, many years. And in fact, I'd highlight that before Paris, it was the High Commissioner for Human Rights who was the only UN principal to call for an objective of limiting warming to 1.5 or even higher ambition. And we drew upon the work of a joint report of special procedures mechanisms that was requested by the Climate Vulnerable Forum, which examined the differences between the human rights impacts of 1.5 degrees of warming and 2 degrees of warming. And throughout our work, we've always said that ambition is a matter of human rights obligation, and that is a science-based statement, right? We're talking about the right to science, we're talking about ambition, and we're talking about the objective we need to protect human rights. If you think about the world we live in today, we're pretty close to 1.5. I think the exact point at which we've considered having eclipsed it a little technical, complicated issue, but we already have massive human rights violations happening across the world on a scale that's really completely unprecedented, and as a result of something that is totally preventable, right, which is climate change. So if you think about the right to benefit from science and its applications, if you think about a human rights-based approach, which is clearly called for by both the ICJ advisory opinion and the Inter-American Court advisory opinion, you see that we have to be doing more, that ambition can be driven by and must be driven by a scientific approach, which, as I mentioned, is also explicitly committed to under the climate regime and commitments. And the last thing or two I'd like to say, and I know, sorry, I'm going a bit long, is that the ICJ advisory opinion also speaks explicitly about attribution and causation, and the fact that we do have a scientific basis for attribution and causation, and that's really important. Now, they emphasize that there needs to be a case-by-case assessment with respect to findings related to causation. But we do have the means of doing that, and they emphasize that this is something that can be done. So when we start thinking about loss and damage and reparations in that context, we have a way forward, clearly identified. And the other thing I wanted to add is just the way that the work of the IPCC itself is addressed in these opinions. They clearly take as a basis the IPCC as the best available science. There is unfortunately still a discussion in the UNFCCC and in the climate negotiations about the extent to which the IPCC should be relied on for decision making. And I really think that drawing on these advisory opinions, that discussion needs to be shut down. We know what the science says, and it is not acceptable that there continues to be a debate, which I would argue is not really in good faith about what the science says. We need to move ahead and move forward, and we can draw on the example of how the highest courts are approaching science and bring that into the context of the climate negotiations and the political process so that the decisions are informed. And the IPCC says that a human rights-based approach that's evidence-based and informed leads to more effective and sustainable outcomes. So it's the right policy choice in addition to just the right thing to do.
Thank you very much, Ben, for this for really kind of showing how much the advisory opinions reinforce the vitality of climate science in informing states' obligations in relation to climate change, which is critical to guiding just and equitable climate action. Thank you for that. Professor Margera, turning to you now, very briefly. I know that the special procedures have contributed to the historic advisory opinions in many different ways and powerful ways. How will you plan to continue to do so in this coming implementation phase?
Yes, there are many, many ways, and hopefully we'll have other occasions to fully explore that range. But clearly, I think several special procedures, not just myself, also the Special Rapporteur on the Human Right to a Healthy Environment and others, have already started integrating the advisory opinion findings into their thematic reports. I think there'll be scope to do so in our country visit reports as well, but also in the whole range of instruments, communication, so working directly together with affected human rights holders to understand how those advisory opinions can apply in concrete situations. And I think the use of press releases as statements to call upon states, call upon international fora, call upon UN bodies to apply those advisory opinions in specific contexts, be that in terms of national action, but be that also in terms of international negotiations, development and monitoring of nationally determined contributions. I think the reference to the negotiations on an international legally binding instrument on business and human rights, there's a lot that we can also contribute there. And also that need, which has been reiterated several times in the context of the Human Rights Council, to reform international investment law, and particularly the role that that area of international law is playing is obstructing the phase out of fossil fuels. We're also there to advise treaty bodies, national human rights institutions, anyone else really, on how we can proceed with priority legal and institutional reforms. And also, as we have done in the past, provide amicus curiae if there's going to be litigation, making sure that the full body of international law, as it has been clarified, is put to use to support protection of human rights, crucially, not only progressive decisions by national and international courts, but meaningful implementations of those decisions. And once again, we are at the disposal of states and any other actors to make sure that those decisions lead to transformative processes for the protection of human rights. Oh, can I say just one more thing? And sorry, just an announcement, which I think I haven't made yet. In terms of my own next thematic reports, they will follow that trail of understanding where fossil fuels are hiding in plain sight and contributing to the implementation of that clarification around phasing out of fossil fuels. So my next report to the Human Rights Council, on which I will start work right now, is on food systems, both terrestrial and marine, including the role of carbon credits. And the next one for the General Assembly next year will be on climate technologies.
Thank you very much, Professor Margera, for that. And we very much look forward to the work that the special procedures continue to lead at the intersection of climate change and human rights. Turning now to Ana Maria. Ana Maria, for many years, has linked what happens in Geneva with frontline communities all around the world. And in this process, where we are asking how UN Geneva can play a role, how can that role bring in communities from the front line? If you could very briefly share your reflections. Thank you.
It will be very brief. Thank you, Joy. And maybe since Elisa already spoke about how special procedures will do, and I think we mainly should speak about treaty bodies and special procedures, I would just like to give some examples, like for example, in the country visits, it would be very interesting to contextualize the stringent due diligence, because the court says that there is not a general formula of stringent due diligence, but that this has to be defined depending on the principle of common but differentiated responsibilities and capabilities. So I think this is an exercise how the special procedures can blend this principle into their recommendations. And I think in the communications to states, which are normally initiated by the affected communities or their advocates, it would be very relevant also to connect and take into account what the Special Rapporteur on Toxics calls the citizen science as part of the right to science, which means not only looking into the hard science, but also in the knowledges and experiences of the communities. And then I think for the treaty bodies, it would be interesting to see how they can expand and go further on the principle of the big polluters pay. The ICJ lets open, it says it's evolving, there are some strict liabilities for some hazardous activities, but it doesn't really reaffirm, different to the Inter-American Court, which recognizes the principle. And I think it would be good that the treaty bodies in upcoming special general recommendations can work on it, or even also in the recommendations to states. And I think also, to only mention another example, while the International Court of Justice says states should look into all the available science to find the solutions, like for example, through regenerative agriculture, it also recognizes that some of these solutions can have risks. Like for example, they don't mention it, but I will call here a report of CL on geoengineering. And I think identifying these risks or even the impact in the reports of the special procedures and the treaty bodies could be very helpful to make these advisory opinions land in the evolving character of our societies. Finally, I think that it is very important that special procedures and treaty bodies continue hearing the rural communities, indigenous peoples, and especially the youth. I think the youth have not been very present, especially with the treaty bodies. And it would be great to create stronger connections, because this movement is extremely important.
Thank you so much, Ana Maria, for providing that landscape of concrete examples of how we can build from here. And to bring in the youth for UN treaty bodies, can I just mention Eula's there? She is an incredible mobilizer. So we should speak to her about that. Bringing it back, Eula, giving you the last word for the panel, and then hopefully we have time for questions. As you mentioned, the youth mobilized and created powerful movement infrastructure on the case, but they also shaped the case from inside on the legal questions. And now that you see the climate rulings, what do you think are the implications of the advisory opinion for intergenerational equity and the rights of future generations? Very briefly, if I may ask. Thank you.
Thank you. It's always a big responsibility to speak on behalf of future generations, but I'll try my very best. Some of the lawyers who've been deeply involved with this case have always said that this is about closing a gap in accountability and ambition. And I think the way both the Inter-American Court and the ICJ have interpreted the intergenerational equity piece and future generations' rights can really do that. It allows us, if we bring these two interpretations together, to raise ambition on all levels. The ICJ has said that considering the rights and interests of future generations is an equitable consideration, and that, and I quote, that need to be taken into account where states contemplate, decide on, and implement policies and measures in fulfillment of their obligations. So a justice-focused interpretation of this would mean that when we assess states' compliance with their obligations, we are to consider whether, or we are to consider the impact on future generations. Concretely, and taking into account the effect of cumulative emissions, which the courts have acknowledged, this will set a much higher bar for state actions. So this becomes very important when we consider, for example, as mentioned several times already today, national planning processes, adaptation planning, or legislation. And a question that Joy and I and others are speaking about also, when we think about climate reparations, what would those look like for future generations? And I'll leave us with that question.
Thank you very much, Yule. And it was a powerful closing for the panel. We have time for a couple of questions from the floor. Sorry, I don't have this on. If there is a question, there is incredible knowledge and expertise on this panel. Would anyone like to share a question or reflection of your own engagement with the advisory opinions? Please, from Brazil.
I think we have too many mics on. Anna, if you could turn off your.
Thank you, Madam Moderator. Thank you for the panelists for sharing your expertise with us today. The advisory opinions confirm positions historically supported by Brazil and other developing countries. It reaffirmed, as we learned today, that the UNFCCC, the Kyoto Protocol, and the Paris Agreement are mutually supportive, and stressed the importance of principles such as CBDR. It also reinforced the historical responsibilities of developed countries and their obligation to provide means of implementation to developing countries. COP30 in Brazil must be a turning point, a moment to uphold multilateralism, connect the climate regime to people's lives, and accelerate our goals. People must be at the center of our thoughts, and we must show the world that the transition can and must be just for all. We believe that the fight against the climate crisis is also a fight against poverty and hunger. So we are ready to work in an inclusive manner to build a path toward a just transition. Thank you.
Thank you very much for those reflections. Is there any other question or reflection from the room that anyone would like to share? Please.
Thanks, everyone. I'll be quick as we were able to speak on the earlier panel from the Marshall Islands. Just a brief question. I can imagine as our mind turns to the General Assembly, countries will be wondering how much this is a call to action for the UNFCCC and how much needs to be taken, how much action needs to be taken outside. And I'm just interested in your views of that. How much can we use the instruments we have within the UNFCCC and have it kind of pull up its socks versus how much do we really need to look to act beyond it now?
Thank you very much for that question, a very central question in a lot of people's minds. I'm happy for any of the panelists to respond to it. Is there anyone who would like to take it? Yes, so I have Professor Vinuelis and Professor Morgera and Benjamin Turk. And then Yula and Anna Maria, if you wanted to add a quick reflection, please feel free.
Yeah, just briefly, just a thought. Of course, I'm speaking in my personal capacity here. The two resolutions that are typically discussed in these cases, I mean, one in the second committee and the other in the plenary, there will be ordinary resolutions that are adopted by the majority. It's very different from what happens in the UNFCCC, in the COP, CMP or TMA. Transitioning away from fossil fuels has not popped up sufficiently in the last two COPs, or in the last COP and in the discussion so far. It's important, and it could pop up in the General Assembly.
Yeah, thank you. Maybe following immediately from this point by Jorge, just to reiterate maybe a couple of points in my report this year to the Human Rights Council, which already envisage both a high level of hope, which is now reinforced by the advisory opinion for COP30, to start a process specifically and explicitly focused on monitoring the phase out of fossil fuel in the light of all existing and applicable international obligations. And of course, all of us will be supporting the Brazilian presidency, the Secretariat, the Secretary General, anyone else who can make this very much needed idea a reality. But equally, we might not know that the climate COP is a very entrenched process with its own, I think, institutional culture, which in very many ways is challenged by the advisory opinion findings, particularly the ICJ. So whether that is not possible or maybe in complement to that, I have recommended to potentially develop another process that could be under the aegis of the Secretary General or potentially be mandated by the General Assembly for something beyond an interstate approach, something where we can hear from actors from across all levels, cities, subnational states, but also bottom-up initiatives on understanding what works in phasing out fossil fuels, learning, supporting transformation, and monitoring a more, maybe in a dialogue-based way, phasing out of fossil fuels by all. The second piece that was recommended in my report, which can't be done under the climate agreement, is of course the reform of international investment law. For that, again, we need a process. There's an opportunity for the General Assembly to mandate for the start of the process. And my recommendation maybe to think about basing that process here in Geneva, having the Office of the High Commissioner or the Human Rights Council potentially working in collaboration with UNCTAD to create a more conducive forum than the ones that have already engaged with this question to ensure support, a whole overhaul of the area of international law to truly and centrally support a just transition and transformation of our economies for the protection of human rights and life supporting systems.
Yeah, briefly, I think two things I want to raise. One is with respect to the discussion on just transition, there will be a report of the Secretary General on human rights, climate change, and just transition presented later at this session of the Council on 17 September. And it is absolutely imperative that we think about just transition as something grounded in human rights. Now, with respect to the question about what needs to happen and where, I would just say that I think the ICJ-AO itself is quite instructive in finding that obligations related to climate change, and very clearly finding so, exist outside of the climate regime. And so we are in what they themselves describe as an existential battle, and they're closing to address the climate crisis. And in many ways, the UNFCCC has led to important and incremental progress, but it certainly hasn't led to progress at the scale and level of ambition that we need. And part of that is built in because it's a consensus-based process. So we'll work as hard as we can to try to push for more ambition there, drawing on the ICJ advisory opinion, looking forward to working with the COP30 presidency and member states. But, and of course all other partners, but we have to look at the other tools available. We have to look at how do we actually create a monitoring and implementation framework that works. We have to look at how do we address the harms and ensure access to effective remedy and access to justice for the people affected by climate change in a meaningful way. And so far, the climate regime hasn't been able to cover all of that because of the way that it's structured itself.
Many thanks for those responses. And I realize that we're at time now. So much gratitude to all our panelists, both on the diplomatic panel and also on the expert panel right now, to all of our co-organizers, and to all of you who joined us today. Really a deep thank you from all of us. And there is a reception now at the Serpentine. Please join us for additional conversations or questions that you might have from the panelists or each other. And our colleagues will be there to guide you. Although I think all of you know the Serpentine.